Good morning, everyone. I'm Olivia Holas for Boca Magazine, and it's time for another coffee break with guest Marius Ged, managing partner of Ged Lawyers, and J. Albert Johnson, senior trial counselor with an impressive list of high-profile, nationally recognized cases representing some of the country's best-known personalities and several of its largest corporate entities. So good to see you, gentlemen.
Thank you, Olivia. Good to be here.
You know, this is such a treat because, Al, you really do have an impressive list of cases, and we're going to get to talk more about that throughout the interview. But Marty, I know you have many practice areas at Ged Lawyers, and inevitably a lot of these cases go to trial. Would you please give us some insight on your expertise and experience in this area?
Sure. I mean, there's so many different variables that go on in a trial. It's important to have a team that's seasoned and experienced in trying cases. And our team at Ged Lawyers has many, many years of trial experience, including our senior trial counsel, Al Johnson, who has the most years of anyone. So we're into the hundreds of years of collective trial experience. And that's really important when you pick a firm, because a lot of firms, Olivia, they'll just sign the case up and they'll transfer it to another firm to actually litigate the case. We don't do that. We actually try our cases in-house.
Okay, well, that's really good to know. And Al, you've participated in the trial of cases in 33 states, both civil and criminal. Can you please give us an overview of your trial experiences and how this is an asset to your present clients?
Sure, Olivia. But before I do, I'd like to pay a tribute to my good friends, to John and Margaret Mary Schuff. John Schuff, as you know, just passed away, and I'm forever grateful for the friendship of both of them. They're magnificent people, and John was an especially good friend of mine. So I want to pay tribute to them as the publishers of Boca Magazine, but also as very influential people in the Boca Raton community, of which I have been a member for just about 30 years now, here in the Boca Raton city of Boca Raton. I originally came from Boston, Massachusetts, and the reason that I am called senior counsel at the law firm is only because I'm the oldest. That's the only real reason. Seriously, many, many years ago, a young man came to my office to work in my law office as a legal assistant and a law student. And that fellow's name was Glen Jed. Glen Jed, along with Marty, is the partners in the law firm in which I now participate. And it is a great, great honor, really, to be able to be affiliated with the law firm of Ged Lawyers. I think I've been around Ged Lawyers for about 20 years in one shape or form of another. And I cannot tell you how important it is to be part of a law firm where trial work is the most important factor. Our system of justice, that is the jury trial system of justice in the United States, is not perfect, not by a long shot, but it's the best yet devised by man for his own governance, and really works. But it only works if you have the staffing of people who can do the job in court and get the results necessary to right the wrong. We don't know how to help people get back their health, but we do the best we can in court. We know how to get damages accounted for against insurance companies and others, and that's our job. And I'm so very, very pleased to be part of that ongoing endeavor at Ged Lawyers. My legal career began many years ago with my partner, F. Lee Bailey, who is very well known in the legal community and elsewhere. The first case that I became involved in with Mr. Bailey was the case of Shepard versus Maxwell. It is a very famous case. It's the case upon which The Fugitive was founded. Many years ago, a fellow named Dr. Sam Shepard was accused and convicted of the murder of his wife in Cleveland, Ohio. Because of the fact that there was so much publicity engendered by it, Lee Bailey thought there was great injustice And the injustice was that there was a circus atmosphere in the courtroom. The courtroom was cleared completely of spectators, except the press. And the noise of clicking cameras and the TV interruptions and so forth caused that trial to be nothing but a circus. Lee Bailey then contacted the brothers of Sam Shepard, who had been incarcerated for 10 years at that time, and took his case on after a polygraph examination clearly showed that he could not and did not murder his wife. The case went to the Supreme Court of the United States, which reversed the conviction, and the case was tried in Cleveland, Ohio, and he was acquitted. So that was the very first case that I became involved in with my partner, Mr. Bailey. Shortly thereafter, after a number of cases, I became involved in the Patricia Hearst case. Many people now are not aware of what the Hearst case was, but it was a case involving a 19-year-old, very wealthy heiress, if you will, who lived in San Francisco, who was attending school at the University of California at Berkeley. She was one night living in Berkeley with her boyfriend when a knock came on the door, and some crazy mad people burst in the house with machine guns, took her captive. It was a political captivation, a political kidnapping. And they held her in a closet for 57 days. She was brutalized, raped, tortured, and she was forced to make recordings denouncing her father, who was then arguably one of the richest men in the United States and the chairman of the board of the Hearst Corporation, television, radio, newspapers. She was caused to make all kinds of recordings denouncing her family. And from the community, she was thought of being nothing but a bad, bad, bad person. Indeed, she was not. She was forced to say all of the things that she did under fear of death. And that was culminated by the fact that they took her along when they robbed a bank. And they robbed the Hibernia Bank in San Francisco, California. Patty was there. She wore a pea jacket and she had a rifle in her hand. And significantly, in the photographs which showed up later in court, she had the rifle pointed away from the teller who was being robbed and toward a fellow who was behind her with an automatic weapon. Indeed, it was her kidnapper, a fellow named CQ, a mad, crazy, radical fellow. Nonetheless, after many days in hiding, Patty was arrested by the FBI and put on trial. And in one of the strangest trials that I have ever participated in, the United States government put on a number of witnesses who correctly identified her as being in the bank, but failed to show the photographs which were in the possession of the FBI, which showed that not only was she an unwilling participant in the bank robbery, but that, in fact, an automatic weapon was pointed directly at her, following threats that if she did not participate in the robbery, she would surely be killed. During the time that she was held captive, they robbed another bank. They robbed a bank up in Carmichael, California. Patty was in the getaway car. She was not in the bank, and a woman was killed during that robbery. The United States government said that during the trial of Patty in San Francisco for the bank robbery at the Hibernia Bank, there would be no mention of the fact that she was present at the Carmichael Bank robbery. Halfway through the trial, the judge, who had promised that he would never allow that kind of testimony to come in, changed his mind. He was a sick man. He had had a number of strokes and was very forgetful. And he forgot that he had guaranteed us that the mention of the bank in Carmichael would never be had during the trial. As a result, the prosecutor asked her about the Carmichael Bank robbery, which had nothing to do with the crime for which he was charged in San Francisco. She answered by proclaiming her Fifth Amendment rights 42 times. the jurors hearing her proclamation of the Fifth Amendment didn't like it at all, and as a result convicted her. Later on, the United States government petitioned the President of the United States to pardon Patty Hearst. In fact, she was pardoned. And in that pardon petition, the government of the United States, which prosecuted her and placed her in jail, said that had she not been an unwilling kidnapped victim, she never would have been tried. And had she never been tried, she never would have been incarcerated. One of the great, great injustices of American jurisprudence. Truly a case which I am very thankful I was able to participate in as her lawyer, but one which goes down in history as being a very, very great tragedy in our system.
I could stay here all day and listen to all of your stories, Al. I mean, how fascinating, right, Marty?
Sorry, it's tremendous. I hear these stories every day, so I'm the lucky guy. This is my mentor. So we talk shop all day long about all these cases, and I'm grateful to hear them and learn from him.
Absolutely. Now, Al, you are known as a lawyer's lawyer. How did that come about?
Well, I represented a number of judges and lawyers throughout the United States in discipline cases, one of which of some significance was the Chief Justice of the Superior Court in Massachusetts, who was charged with driving a motor vehicle under the influence. Judge McKinney had been at a party at the president of Boston University's home, and had left that party and had been stopped by the police and charged with operating under the influence. I summons in the president of Boston University, and the President Silber at that time, came into court and was asked a question as to whether or not he observed anything unusual about the way Judge McKinney walked after he was arrested. The answer was no. Did you observe anything unusual about the way he spoke, about how he conducted himself during the time that he was entertained at the president's home? He said no. He said, can you tell us whether or not you have an opinion as to his sobriety at the time that he was stopped outside of your home? And he said, yes. And what is that opinion? He said he was sober as a judge. Indeed, he was a judge.
Oh, that's great.
He was found not guilty, by the way.
Oh, well, that's great. You know, Marty, a lot goes into preparing for a trial. How does your firm prepare for complicated trial litigations?
So we're very lucky. We actually have in our office building a mock courtroom with video technology and audio technology. So if anyone were to walk into our office building on Federal Highway, we have a mock courtroom. There are not many lawyers across the country that have this device or this tool. So we practice, we practice, and we practice again. And what we do is, you may see sometimes we have ads in the paper for jurors. We'll actually go out and hire independent people in the community. We'll put them in the jury box and we'll try the case. And we'll bring in a defense attorney and a plaintiff's attorney, and we'll work the case and we'll try the case. We call it mock trial. We'll mock try that case many times. And then we video record it and have audio as well. And you get to see the deliberations. You get to see your client's strengths, weaknesses, flaws. I've never met a plaintiff who thinks that their case is not completely correct or they're the most right person, which is not necessarily the case. And we use that tool as a advantage to us, which is our secret weapon, really, that mock courtroom.
Wow, that's really interesting. I mean, I would love to have a tour of that mock trial room. I mean, that sounds really great, and really a great way to prepare for any scenario that will actually happen when you're in trial. So that's really great. Al, which of your trial cases stands out as the most challenging, and why?
Well, just to add a little bit to what Marty said about the trial courtroom at our office, every case that we have must be tried before it goes in the regular courtroom. And I should add, every time we go into the regular courtroom following a mock trial in our courtroom, the result is greater. We get a lot more money at trial than we have previous to that time by settlement, since the the trial parameters have already been set. I think one of the strangest cases I ever had was I received a call from a highly placed appointed government official in the Department of Justice. And I was asked to come to Washington, D.C. to represent a fellow named James McCord. James McCord was one of the Watergate burglars who you may have heard of and may not have heard of. You know, the Watergate complex in Washington, D.C. housed the Democratic National Committee headquarters. 5 gentlemen, if I do say so, 5 gentlemen broke into that Democratic National Committee headquarters and stole a bunch of materials and some radios from that edifice. They were arrested and charged. When I arrived in Washington, D.C., 2 mornings after the break-in, the headlines were full of the fact that the Republican operatives had sent Democratic people Republicans into the Democratic National Committee headquarters, and my client, James McCord, had been charged with breaking and entering into that complex. James McCord refused to speak to anyone regarding what his motivation was in breaking into the Democratic National Committee headquarters. But the United States Attorney, who was in charge of that case, came to me and said, "We can make this very easy. If you have your client return the radio, which he stole, and if you pay $100 in costs, this case will be dismissed." I went to my client rather gleefully and told him that the case had been over. For $100, he was out. And he refused. He refused to say where the radio was, refused to pay the $100, and he was held. And after a 6-week trial in Washington, D.C., before a judge who was a real tough guy, Judge Sirica, during that trial, my client, James McCord, got up, approached the bench, and told the judge that the reason he would not participate in his release from custody was that everything he did was personally under the direction of none other than Richard Milhous Nixon, the President of the United States. So he was convicted, of course. And were it not for the fact that James McCord told Judge Sirica that Nixon made him do it, break into Democratic National Committee headquarters, Nixon might still be president. I'm only kidding, of course.
Wow, what a story. I mean, you have mentioned also before that, sometimes the media gets in the way, and, especially now with everything that we have, the internet, social media, the press, how difficult is it to ensure that they're not going to interfere in a fair trial?
That's a very good question. I mentioned before about the case of Shepard versus Maxwell,
right,
involving Dr. Shepard. In that case, the United States Supreme Court set the boundaries for pretrial prejudicial publicity. And the Supreme Court of the United States said at that time, which is still the law, if a trial judge observes inordinate pretrial prejudicial negative publicity about a defendant, then the trial must be continued until the publicity subsides. The venue of the trial has to be moved to a place where the publicity is less virulent, which is very difficult nowadays, and the jury must be sequestered. Those 3 things: move the trial, sequester the jury, and make sure that the trial be continued. Now, that rule has been violated thousands of times since the advent or since the trial of Dr. Sam Shepard. And it's a very great problem in the United States today. O.J. Simpson, for instance, those cases stand for the fact that the press, oftentimes by pretrial prejudicial negative publicity, a case which I had up in New Hampshire involving Pamela Smart, who was accused and tried and convicted of having others kill her husband. Those cases were ruined legally by the presence of the press and by the comments which were made by others pre-trial, which were negative and could not help but influence the jury. So we have to be very, very careful, especially now with the advent of television and the way that cases are publicized before trial. It is very difficult now to get a fair trial for a widely known case, a widely known defendant charged with a crime, because of the fact that jurors who listen to that information being publicized on TV and listen to people such as the Attorney General of the United States in the Patty Hearst case, who named her a common criminal prior to trial. Those things are listened to and heard by jurors. It's very difficult to imagine that they will not be affected in their deliberations. So it's a real serious case, real serious matter for judges to be acquainted with the fact that they must, in order to make sure a trial is fair, they must continue the case, they must move the venue of the case, and they certainly have to sequester the jury, which doesn't happen. So it's a serious matter. I'm glad you brought it up.
Right, that's definitely a challenge. And Marty, what do you find is the most important trait when presenting yourself in a trial setting?
I think you need to be honest, and you need to convey your trustworthiness to the jury. And you really need to be a good orator and tell a good story. I mean, you see these TV shows with like LA Law, that's not really how it happens. It's a connection with that jury. You need to tell that story and really convey your plaintiff or your client's position in layman's terms, not in legalese or scientific talk. You got to relate to those people, and they have to believe you, because as an advocate for your client, if they don't believe you, there is no chance in any way, shape, or form they're going to believe your client. So I believe one of the most important things is building a rapport with the jury.
All right. Well, my last question, which of course Marty knows, we always ended with something a little bit more personal. I can only imagine how much tension you must be feeling, when you're, during trial. How do you stay calm, cool, and collected? Marty?
Well, I think you have to have a routine like anything else, similar to sports or whatever your thing may be. You need to have a routine and you need to keep repetition, but you have to do, there's so much work that's involved in the weeks and days and months before a trial. Our team is rigorously going through every scenario possible. Obviously, you plan and practice for every scenario, but you still go to trial, and there are things that just pop up that you never thought of. So really, it's repetition, it's trial, it's practice, it's having other people critique you. We have wonderful attorneys in the firm, and those people play the defense attorney in these mock trials, and they know things that they obviously that is an advantage for them being in the firm, and they push those buttons and they try to explore every avenue or every sort of issue that may come up in a trial. So it's really the hard work, it's the grind.
What about you, Al? How do you stay calm, cool, and collected under pressure?
Well, I think it's important to note that we have 100 employees in the office and thousands of cases presently pending. And because of the fact that we have a large staff in the office ready to assist us, we keep in touch with every single client, so that by the time a case becomes ready for trial, if it's not settled beforehand, we know the client. We know the client well. And the watchword, which was instilled upon us many years ago by our founding partner, Ged, is compassion. Compassion always. So each lawyer in the office is filled with that tone of compassion, which allows us to understand the client, understand what the client has gone through because of their injuries or their damage as a result of what has occurred. And because of that, because we know them so well individually, because we know them so well personally, it's really easy for the lawyers in the firm, be it Marty, be it Glenn, or the other lawyers in the firm, to present their case because of the intimate relationship we have had with each and every client.
Well, great. Well, thank you so much, gentlemen, for chatting with us today. I really think that the two of you could write a book, because I could spend all day listening to all of your cases and stories. I mean, thank you so much for sharing with us.
Thanks, Olivia. Great to be here.
Thank you, Olivia.
Yeah, thank you. And thank you to our viewers for tuning in. Until next time, stay well, stay healthy, have a great weekend. We'll see you soon.